Thank you very much, Mr. Chairman. Thank you to both of you for appearing before us today. I know Professor Barrett that Senator Feinstein discussed this 2013 piece in relation to stare decisis, this article you wrote. In that same piece, you also address the role of precedent in controversial areas of the law, stating that in the world we live in, that level of stability is more than we have experienced or should expect in particular divisive areas of constitutional law. You noted that you tend to agree with those who say that a justice's duty is to the Constitution and that it is thus more legitimate for her to enforce her best understanding of the Constitution rather than a precedent she thinks clearly in conflict with it. So my question would be how important do you think stability is in the law and balancing that constitutional view and precedent that you may not agree with? Where do you see stability in the law factoring in?
Thank you, Senator Klobuchar. I think stability is very important in the law. In that 2013 article in the Texas Law Review, I was defending the Supreme Court's own doctrine, which gives weaker stare decisis effect to constitutional cases. The court has had that practice since Justice Brandeis wrote a separate opinion in Coronado oil and gas case, saying that constitutional cases should receive the least precedential effect compared to statutory or common law cases because the difficulty of amendment means that the Supreme Court's overruling of the case is often the only way to correct the error. And in the portion that you quoted where you said that I said I tend to agree with those, I was actually responding in that paragraph to the argument that it's never permissible, that the rule of stare decisis should be hard and fast. And I was quoting Justice Douglas has a famous piece about stare decisis where he was writing actually about his view of the living Constitution, saying that if the Constitution was to evolve, that sometimes that meant leaving precedents behind. And so all that quote was, or that portion was designed to say is that the Supreme Court has never accepted, I'm not aware of any justice who has, the view that it's prima facie illegitimate to ever overrule precedent. You know, that the court's policy, its doctrine of stare decisis says that there are some circumstances in which overruling is warranted.
Okay, thank you for clarifying that. I appreciate it. You've also written on methods of constitutional interpretation, including on the doctrine of originalism. Last year, you co-authored a law review article titled Congressional Originalism that discussed the role of pragmatism and strategy and how originalists approach or try to overturn precedent. The article asserted that the office holder has the discretion to decide when the timing is right to challenge a precedent with which he or she disagrees. I know that's particularly focused on Congress, but I wanted to ask if you believe the same concept applies to judges. And in other words, do you believe that an originalist justice on the Supreme Court should bide his or her time until there is an opportunity to overturn a particular precedent?
Senator, as you say, that particular article was focused on Congress, but in the earlier 2013 article in the Texas Law Review that you referred to, I did talk about judges and how that might play out there. And what I emphasized was that in addition to the strength of stare decisis, there are so many other mechanisms in the law that contribute to stability and that restrain judges from kind of roaming around and correcting precedents that they may not like or that they think are wrong, including the case or controversy requirement, the rule that judges only decide the question presented before them. And so that these and other mechanisms serve to restrain judges and prevent them from reaching out and trying to decide, aha, the time has come and I'm going to overrule this precedent. So no, on the contrary, in the judicial context, that Texas Law Review article makes clear that these rules that the court has imposed on itself, and I was focusing on the Supreme Court, contribute to stability and restrain the judge's hand.
Okay, very good. Justice Larson, I understand you've also commented on the doctrine of originalism, and I believe that some lines